just a reminder, everything will be a roll call vote because Mr. Harb is participating.
Probably forget a couple of times, but we'll work on it. We'll call the meeting to order. It is 9:30, close to it, for the March 11th, 2015 meeting of the Collection Service Board.
Yes, sir. Bart Howard. Elizabeth Trinkler.
Present.
Elizabeth Dixon. Absent. Chip Hellman.
Present.
Steve Harp. Steve, are you with us? Mr. Harb?
Steve?
Got to make sure I don't have it on mute or something.
Oh, I think you did.
Yeah, let's try it again.
Steve Harb is participating via telephone.
Present by phone. Did you hear me?
Yes, I'm going to turn it up a little bit here.
Okay, thank you.
Notice of the meeting. This meeting's date, time, and location have been noticed on the Tennessee Collection Service Board's website, included as part of this year's meeting calendar since August 4th, 2014. Additionally, the agenda for this month's meeting has been posted on the Tennessee Collection Service Board's website since March 4th, 2015. This meeting has also been noticed on tn.gov's public meeting calendar.
Would everyone review the agenda? Steve, do you have a copy of the agenda?
I have everything printed in front of me, and I have everything on my screen that you all have that Kimberly was able to send me, so I can go with the tabs and everything. You just go right on through it. I have the agenda right here.
Okay, pal. We'll have a review and adopt the agenda. All in favor of adopting the agenda?
We'll need a motion and a second.
I make a motion we adopt.
I second.
adopt the agenda.
Motion's been made and seconded. All in favor? Roll call?
Bart Howard.
Yes.
Elizabeth Trinkler. Yes. Elizabeth Dixon is absent. Chip Hellman.
Yes.
Steve Harb.
Yes.
Passes, sir.
We have a copy of the minutes of the last board meeting in front of us. If there are any questions about that or adoptions to that, let's hear those. Otherwise, I'll accept a motion to approve those minutes.
I move we approve the minutes.
Second.
Motion's been made and seconded. Ms. Whaley, if you'll give us a roll call, please.
Bart Howard.
Yes.
Elizabeth Trinkler. Yes. Elizabeth Dixon is absent. Chip Hellman.
Yes.
Steve Harb.
Yes.
Motion carries, sir.
I have a question.
Yes, sir.
At our last meeting, did Chip chair that meeting, or was Bart there at the last meeting?
Bart was there. Is there a correction?
Well, I apologize, Bart. I obviously can't remember, but I know Chip. Chip, you handled a recent meeting. I thought it was the last one, but
No, it was the one before that.
It was the November meeting.
time flies when you're having fun, doesn't it?
Yes.
Thank you.
Budget presentation.
Yes, Deputy Commissioner Giannini and Assistant Commissioner Brian McCormack should arrive shortly. We can proceed on if you'd like and come back when they
Let's
arrive.
do that. Let's proceed on with the legal report. Ms. Baird?
This is tab 3 on your iPads.
So you guys know, I welcome comments because I still feel like I'm kind of learning as I go. So if you feel like I'm getting off track with something, please just let me know. Okay, item number 1, 2014-018-131. This complaint alleges that respondent failed to timely submit to the board proof of current surety bond coverage as required by law. Respondent's bond expired on July 1st, 2014. The investigation revealed that the respondent errors which led to the delay in providing proof of surety bond coverage to the board. This licensee has not had any prior disciplinary action imposed against it by the board. This respondent provided written assurance that the issues which led to the delay in timely providing proof of surety bond coverage have been fixed to prevent this from happening again. However, respondent never submitted proof of current coverage to the board and is currently without proper surety bond coverage. Council recommends the authorization of a civil penalty in the amount of $250 for failure to timely provide proof of current surety bond coverage to the board to be satisfied within 30 days of execution of the consent order. Such terms to be settled by consent order or formal hearing.
what we probably will do is go on with those, and if there's any questions, we'll interrupt you. Otherwise, we'll approve them all at the end.
Okay, that sounds great.
I do have a question.
Okay.
Are you requiring the proof of surety coverage within 30 days as well as the fine?
Yeah, I mean, we can put that in the consent order. We can certainly put language in the consent order stating that this person would be required to provide that.
And what will be what will happen if they don't provide it in 30 days? Will their license be pulled? Would we inform them of that, or would that happen, or would they have to come back to us?
Up to the commission as to what you all see appropriate in that situation. I feel like this is kind of been going on for a while. This is a matter that Chris actually was handling before I came on board, and I was reading his notes in the file, and this is what he suggested. However, I'm open to you guys letting me know what you think would be appropriate if that surety bond coverage was not provided in that 30-day time period.
So has this company already had an opportunity to provide the surety bond coverage and has not?
They did, and apparently, from what I read in the file, I think they were saying they were having some delays with the mail and this and that, but they assured us they were going to get us that surety bond coverage, and that has not happened.
Not sure what the procedures are as far as noticing them that of their pending license, whether we have to give them 30 days notice or what have you, but I think already know that we don't have the surety bond coverage, then we should be in the process.
Wouldn't the request for the 30 days to settle it be the same as 30-day notice? Could we give them notice of pulling it at the same time?
Right. We can use the consent order as notice. I can put language in there and kind of make that also serve as notice that not only do you need to pay this $250 penalty, but you also have 30 days from this point to provide us with the current surety bond coverage. And if not, then we're going to pursue revocation.
Is there an alternative to surety bond coverage, like they can put up a certain amount of money themselves?
Not to my knowledge, no.
Is any of the board members aware of anything?
I
like
think
that?
you can put up a letter of credit.
Yeah, you can put up a irrevocable letter of credit
You
for
can.
the same amount.
Offer that option to them instead, and if they don't do it in 30 days, then pull their license?
If that's what you think would work better, we can do it that way.
I think so. I'm just not sure when we give them this opportunity to provide the coverage, do we have to go through another process to pull their license?
Well,
Or does it automatically revoke if they don't give it to us in
Because
30?
they're not in compliance, yeah.
I don't believe that the way our statute reads, I don't believe it would automatically revoke them. I think that we would have to go through another process because that is a property right. So they would be entitled to something besides just having it revoked. And
If
our
we-
statute doesn't read that way, so.
So if we tell them in the letter that you're going to send us $250, sign the consent order, and provide us proof of surety coverage, or we're going to begin the process of revoking your license.
Correct, and that's kind of what I guess a formal hearing would serve as that too. And we're authorizing also, if this doesn't get settled by a consent order, you guys are authorizing a formal hearing at the same time. So if within that 30 days they don't comply, then formal proceedings would start.
does it take formal proceedings to revoke a license?
Yes,
Yes, because it's
in
a
this case it would.
Yeah, it's a property right, so we'd have to have a formal hearing, unless they willingly gave up their license.
Well, kind of what we're saying is that somebody just really doesn't have to put up the surety bond, and you can't really do anything about it except charge them a penalty.
You can
30 days they don't have it, we'll charge them an additional $250, the increments of 1,000.
I mean, you can do something about it. It just takes a little bit longer. It's more of a process than just saying if you don't give this to us in 30 days, we can revoke your license, because we don't have language saying we can automatically revoke. So you can do something. It's probably just takes a little bit longer than you might like. But I see what you're saying too.
Yeah, I mean, can we tell them if they don't have it in 30 days, that will be another a penalty of 500, and if they don't have it in 30 days, it's 1,000, and meanwhile we're revoking your license. I mean, put some because obviously they've ignored us now
They can do what they
from the
want.
time for more than 30 days.
I'm not sure that by increasing the size of the penalty would serve any real purpose. I think if they don't provide us the surety license, the surety coverage in the 30 days that they're getting in the consent order, then we begin the process of revoking their license.
Okay, sounds good to me.
Right, and also the formal hearing that can always result in greater penalties. That's really probably the best way to handle that, just to get to that phase, and then if you decided that you think it might need higher penalties than what we said in the consent order, then that could be taken care of there.
Let's have a roll call vote on that procedure then, if you would, please, Ms. Whaley.
Do we need a motion?
Let's make a motion about
Exactly what.
the recommendation on this particular one, and then if you want to go through and just cover all the rest before you approve them, that's fine. But since this one's kind of tricky.
Chairman can't make a motion. Would,
Steve, you want to make that motion?
Sure. I'd move that we follow the recommendation here, but in addition to the recommendation, notify them that we will begin proceedings to revoke their license if they don't comply. We should probably let them know that they can also do a letter of credit, which would meet compliance, and move to a formal hearing if they don't comply within 30 days to revoke their license.
all in favor of the motion, roll call, please.
I'll need a second.
I second.
Art Howard,
Yes.
Elizabeth Trinkler,
Yes.
Elizabeth Dixon is absent, Chip Hellman,
Yes.
Steve Harb.
Yes.
Okay, motion carries, sir.
Okay, Assistant, or Deputy Commissioner Bill Giannini is here, and Assistant Commissioner Brian McCormick have just come in so we'll suspend the legal report and let them do with our budget.
Certainly.
Welcome, gentlemen.
Chairman, this is Brian McCormack. He is the new Assistant Commissioner for the Division of Regulatory Board. And the gentleman handing out the documents is Bill Huddleston. He is the Accounting Manager for the Division of Regulatory Board.
Good morning, everyone. Deputy Commissioner Giannini apologizes, had something come up, so you're stuck with me this
I
morning.
do that every time. Tom.
So I'll just give you all a second to look over this. Let me know when you're ready.
Kimberly, is this the same report you sent me?
Yes, Mr. Harb, I do apologize. You will find this located on tab 2.
Yes.
The budget presentation?
Yes. Okay, thank you.
Yes.
Okay, if you're all comfortable moving forward, I'll just kind of give an overview, and then if you have any questions, please feel free to stop me, or we can answer questions at the end. And as you can see, we'll just kind of look at total expenditures and this is the you can look, it's at 173,457 from last year, which was overall down from the previous years. Going down to looking at the total expenditures, it's at 286,927, which is also down from the previous years. Your total cost backs are down, and looking at your licensing revenue here for this year, you had $295,995, leaving you with a fiscal year balance of $9,067, which takes your total reserve to $276,719. We're implementing a new licensing system. Our current system has been around for a long time. I think it was implemented in the early 90s and DOS based, which can kind of tell you how old that system is. And so we're upgrading it. And so the way we're doing that is we're paying through the reserve expense. Each board is paying for a share of that total licensing system. So by doing this, we're able to spread the cost across all the boards. And so we're getting a pretty comprehensive system for a reasonable cost for all the have any questions?
I do not, unless the commission has, or the board has any questions specifically related to it.
No.
Okay.
Entertain a motion that we accept it.
Oh, it's informational. No need to
Oh,
accept.
Good, good,
No motion needed.
super.
Thank you.
Gentlemen?
Thank you all.
That was the close from 2014, and later on this morning, I'll present with your current numbers for 2015.
Turn the meeting for just a moment. I've left my folder in the minutes.
Oh,
Just
absolutely.
give me 5 minutes.
Absolutely. Okay.
Thank you for the delay. Thank you, Steve. I found my folder, and we'll reconvene the meeting, Collection Service Board. After the budget report, we'll go back to the legal report.
Sorry, I thought we were waiting on something else. Item 2, 2014026781. This complaint alleges respondent has contacted complainant instead of complainant's attorney after being given notice not to do so. In addition, the complaint alleges that complainant disputed the debt and requested verification of said debt. However, respondent has failed to give complainant verification. On June 16, 2014, complainant's attorney sent respondent a letter directing them to cease all contact with complainant, disputing the alleged debt, and requesting written verification. On July 29, 2014, complainant alleges that respondent directly sent him another collection notice despite his attorney's directive. On August 12th, complainant's attorney sent another letter to respondent, urging respondent to provide written verification of the alleged debt and informing respondent that it was in violation of the Fair Debt Collection Practices Act 15 U.S.C. 1692C, which provides that a debt collector may not communicate with a consumer in connection with the collection of any debt if the debt collector knows the consumer is represented by an attorney with respect to such debt. On October 3rd, respondent sent complainant another collection notice, but no verification. Respondent failed to send a response to the complaint. Legal counsel contacted complainant's attorney on March 4th, 2015. The call was not returned by counsel for complainant. Counsel recommends the authorization of a civil penalty in the amount of $500 to be satisfied within 30 days of execution of the consent order for violation of TCA 6220-115B5. The statute states in pertinent part, the board may suspend, revoke, or refuse to renew any license held under this chapter for any of the following causes: failing to comply with any applicable state or federal law or regulation pertaining to the credit and collection industry, such terms to be settled by consent order or formal hearing. Should I just keep going?
Pretty serious violation, and I'm not sure that they'll ever pay anything, but I might recommend, it seems to me that they violated 3 times that they contacted the debtor after they were advised that they were represented by an attorney. The verification, those are 4 violations of our statute, and if approval of the board and a recommendation from the board, I would suggest a $4,000 civil penalty, and continue with the formal hearing.
Yes, that's perfectly fine.
I'll make that motion.
Motion's been made and seconded. Ms. Whaley, if you'll have a roll call, please.
Second by Ms. Trinkler. Art Howard. Elizabeth Trinkler. Elizabeth Dixon is absent. Chip Hellman.
Yes.
Steve Harb.
Yes.
Okay, motion carries, sir.
Thank you. Okay, Ms. Beard.
Item 3, 2014026981. This complaint alleges that respondent has called complainant, a Tennessee consumer, daily for someone that gave complainant's phone number to respondent. Complainant stated he does not know this person, has never heard of him. Respondent is not licensed with the Collection Service Board in Tennessee. Complainant attached a list in the file documenting the number of times respondent has called him from September 1st, 2014 to October 3rd, 2014. The list contains approximately 100 phone calls from respondent. Respondent failed to respond to the complaint. It appears that Respondent Company, while unlicensed in Tennessee, is collecting its own debts as they pertain to automobile loans. There is insufficient evidence to prove a violation on the part of Respondent. Thus, council recommends this matter be dismissed.
If we could, since we've already had single votes on each one,
Okay,
we kind of changed course.
I got you.
So, just for simplicity too,
Yeah.
as well as in the minutes documenting, it would be cleaner if we did that this time. I apologize.
That's okay. I move we approve the recommendation on item number 3.
Second.
Motion's been made and seconded that we approve the legal department's recommendation on number 3 of the legal report. All in favor? Oh, sorry, Ms. Whaley.
Barth Howard,
Yes.
Elizabeth Trinkler,
Yes.
Elizabeth Dixon is absent, Chip Hellman,
Yes.
Steve Harp.
Yes.
Thank you. Motion carries, sir.
Item 4, 2014026991. This complaint alleges respondent called complainant on June 6, 2014, stating he was an investigator for the state of Tennessee, investigating a criminal complaint against complainant, and gave her a case number and phone number. Complainant alleges the caller wanted her to verify who she was. Complainant alleges that she asked the caller what the call was concerning, as she did not want to give any personal information to anyone. Complainant alleges that the caller began to yell and stated that she could either verify the information or he would just forward this information to the state's attorney, and he would be on her doorstep to arrest her if she did not verify who she was. Respondent is not licensed with the Tennessee Collection Service Board. Complainant alleges that she Googled the phone number given to her by the caller and it showed it was placed in Texas. Complainant alleges she found no connection with the state of Tennessee. Complainant then found out the caller was an investigator that did work in Tennessee, but also handled cases in Kentucky and a few other states. Complainant alleges she also received an email stating that a criminal complaint was about to be filed against her with no explanation as to what the complaint was for. The website that was cited in the email contained the name of Respondent Mediation Service, but it appeared to be mediation in regards to family services. There is no mention of any sort of bill collections or criminal complaints. Complainant states she is not sure if this is regarding a medical bill because she does not have a lot of those currently. However, threatening her with being arrested and personal visits to her door has caused her a lot of stress and anxiety. Complainant alleged several violations of the Fair Debt Collection Practices Act. Complainant filed additional information with this office on January 23, 2015, stating that since the complaint was filed, she has been receiving more harassing phone calls from different organizations pertaining to the same matter. Complainant claims it is the same person making all the calls, but stating he's claiming to represent various collection agencies. Respondent failed to respond to the complaint. The individual making the calls to the complainant never identified himself as working for or in conjunction with Respondent Mediation Company. No violation was found on the part of Respondent Mediation Company, and it was never found that Respondent Company was attempting to collect a debt from complainant. As such, council recommends this matter be dismissed.
We have an address for this person that's been calling.
Don't have an address for him. The only thing that I know I could do is, I guess, try to maybe search his name or something, but the problem is the person who was doing the calling was giving a particular name. I don't believe that was his actual name. I think he used about 3 or 4 different names, and some of them were famous people. So I don't really know. I just know that the respondent whom this complaint was filed against, there was no connection with this company whatsoever. So I don't believe it should be opened against them.
Yeah, I move we accept the recommendation on item number 4.
Is there a second?
A second.
Roll call, please.
Bart Howard,
Yes.
Elizabeth Trinkler,
Yes.
Elizabeth Dixon is absent, Chip Hellman,
Yes.
Steve Harp.
Yes.
Thank you. Motion carries, sir.
Okay, item 5, 2014028551. This complaint was filed alleging respondent violated TCA 6220-115B5 and the Fair Debt Collection Practices Act 15 U.S.C. 1692 B and E by contacting complainant's father-in-law on 2 separate occasions regarding a debt complainant owed to a check cashing company. Complainant alleged respondent told her father-in-law that unless complainant called back, she was issuing an arrest warrant. Complainant stated she called respondent and asked what company respondent was working with, and respondent stated she was not working with the company, rather she was working alone. Respondent also alluded to the fact that she used to work for a collection agency, but that she had taken over the accounts and was working on her own currently. Respondent filed a response to the complaint admitting that she did call complainant on October 31st, 2014 regarding a check that complainant wrote on a closed account, but stating she told complainant she was working for a check cashing company to try and get people to pay for their returned checks. Respondent also stated she did not threaten the complainant in any way. Respondent stated she never threatened to issue a warrant for complainant's arrest. Respondent stated she did tell her that a civil warrant could be issued for both complainant and her husband, as this is a joint checking account from which the bad check was written. Respondent also sent proof of an email from complainant to the check cashing service stating that she currently has an outstanding check with the company and she wants to repay the money she owes. However, she cannot pay it all at once. Complainant stated in the email that she could pay $10 a week toward her arrears. Once they decide to give her work hours back, she can increase the payment. Complainant enclosed a money order in the amount of $10 as a good faith payment. Subsequently, complainant sent written correspondence to respondent's company stating that pursuant to her federal rights under debt collector laws, complainant is requesting that respondent cease and desist communication with her as well as her friends and family in relation to this debt and all of the alleged debts that respondent claims complainant owns. Counsel recommends the authorization of a civil penalty in the amount of $1,000 to be satisfied within 30 days of execution of the consent order for unlicensed conduct. Such consent order is to contain cease and desist language applicable to the respondent and any agents working on its behalf, prohibiting the respondent and its agents from collecting debts in Tennessee until and unless appropriate licensure is obtained. Such terms are to be settled by consent order or formal hearing.
A check cashing company, was it a check advance company? Or could we tell?
I'm not sure if it was a check advance company. I do know that the check cashing company that we're talking about in this complaint is also doesn't have any kind of license with us. And apparently this respondent is an individual person who alleges that she told him she was working on her own and had taken over the accounts from this place, but she's alleging that she still is collecting the debts for the check cashing company. And neither one of them are licensed, so.
An employee of the check cashing company, or is she just working as an independent contractor? Do we know?
The respondent herself claims that she is in fact working for the check cashing company. So I don't know if the complainant just made those allegations and wasn't really sure, but the respondent in her response claimed that she was working for a particular check cashing company, not as an independent contractor.
Is this first party collections? Because the check was written to the check cashing company, or do we know?
I don't know the answer to that.
That's what it sounds like to me. It sounds like they're just trying to collect their own debt.
Kind of like that car company above that was far more egregious, but was collecting their own auto loans. I mean, if the check was made to the check cashing company, they're just collecting their own bad check. But if the person's an independent contractor who's acting as a collector or a collection agency on her own and not being paid by the check cashing company, then we could go after her, but not the company.
Right, and unfortunately, I don't know if this person is being paid directly from the check cashing company. I don't know the answer to that.
I think if this person is a contractor of sorts with the check cashing company and she or he's not doing collections for other check cashing companies or other clients, then I'm not sure that it would be a collection all under our purview. Is there any other discussion, Chip? What do you think?
No, if she's collecting on behalf of the check cashing company, they do not have to be licensed, right? So
Maybe that's what we need to ask for proof of, that there is some whether or not she is an employee of the check cashing company or not, and that they need to provide us payroll. If she is, then
she's not using a third-party name.
yeah, she's not using a third-party name. She's not doing it on her own.
I was rereading the very first paragraph. It says, respondent also alluded to the fact that she used to work for a collection agency, but she had taken over the accounts and was working on her own currently. So I guess we have to clear that up. how is she paid?
Well, what name did she use? If she did it in the name of the check cashing company, the fact that she's paid by a 1099 rather than a W-2, I don't know that wouldn't be first party because they have a relationship. Now, that would mean she's acting as an independent agency on her own, so, yeah, that could be a problem.
I think we just need more information on that relationship before we can what to do.
Calling in the name of the check cashing company as an individual, then I don't think she would be a collection agency. Working for the check cashing company, I don't know that how she gets paid has anything to do with it, or even if she does get paid. I do think we need more information and some communication with this collector as to what her relationship is to the check cashing company as far as, and is she collecting debts for any other check cashing company or any other creditor? And does she collect in the name of those creditors or in the name or in her own particular name? Motion that we, is there a motion?
Motion is, I guess, that we defer this until the next meeting to allow for more investigation.
The gathering of the information you just referenced.
I'll second.
Motion's been made and seconded. Ms. Whaley, if you'll call the roll, please.
Certainly. Bart Howard,
Yes?
Elizabeth Trinkler,
Yes.
Elizabeth Dixon is absent, Chip Hellman,
Yes.
Steve Harb.
Yes.
Motion carries, sir.
Very good report. Thank you. On the agenda is a complaint comparison report.
Yes, sir. What I have, this is on tab 4. What this shows is the current number of complaints that we have open and our 180-day performance measure. We strive to close or refer for legal action all complaints within 180 days of receipt. Currently, the Collection Service Board is at 94.34%. So we are meeting and exceeding the performance measure, and that is a divisional performance measure that we report externally as well. So
Fantastic.
Yeah, it is. It's good.
I've seen it below 50% before, so way to go. Monthly budget, know where we at. Monthly budget report?
Yes, sir.
Tab 5?
yes, tab 5. The first page has the revenues listed, and this revenue will encapsulate all of the revenue from the renewal cycle, which many of you are aware that December of even years, the majority of the agency. And then on the next page, you will see the current expenditures for the board of $74,828. So we are in good shape compared to our revenues. So if anyone has any questions. Okay. All right.
Do we need a motion?
Can you give me just a second to
Yes,
look at
certainly.
it? I'm sorry about it. Motion to accept this or to approve this? No? Okay.
This
Thank
is
you.
purely informational
Okay.
and to allow the board time to ask any questions that they might have. Okay, next, we're going to discuss, I have 2 applications that I need to present to the board. The first of which is not on your iPads, and I have the hard copy. If anyone, when I begin discussing, if anyone would like to see it, I will be happy to pass it around. The reason I'm presenting this application to the board for approval is the company has, we asked the question about any civil proceedings In the past 7 years, have you had any type of civil judgment against your agency? And in that, this company disclosed a large number of FDCPA violations spanning across several states. There's 17 in total. There's not really any detail about the violations. It's simply they settled with each of the complainants, ranging anywhere from, trying to see what the lowest was. The lowest was $750. The highest was $6,500. So if anyone would like to see that, just it's a large number of violations. So
I just have to comment on that because that seems like a large number, but it depends on how large the organization is. So we were talking a little bit before the meeting today, whereas in years past, there were very few lawsuits. The regulatory environment and consumer attorney environment is such that these large, in my consulting work in this industry, I'm finding companies that are being sued 3 and 4 times a month now because of these consumer attorneys. These are large companies. And so I think, in my opinion, you can't just say because they have 14 alleged violations that it depends on how large they are. I mean, if they're making millions of calls a month, that may not be all that many.
we don't have that type of information. We could look at the size of their revenue. That's the only information.
The number of employees?
Only ask whether it is, what is the breakdown? The 1 to 4, 5 to 9, and 10 plus are the breakdowns for the bond. That's the extent of what we ask for. Again, this could trickle into, at the end of this, we wanted to have a conversation about reviewing the applications and reviewing the application itself to see how we need to change that because the environment has changed, the industry has changed, and I don't know the last time that the Collection Service Board's application was reviewed and changed or updated. So I'd like to pursue that with the board, but Mr. Hellman, I can hand you this file if you would like to.
Well, I would be interested, I'd be glad to look at it, but I'd also be interested in what their revenue, how large of a company are they?
What size bond did they get?
I'm sure it's the 10 plus.
Plus.
Let me flip through the page.
I'm not sure that we can, I'm not sure that we can, based on the number of complaints that they've had, as long as they're, I think, for certain, we need to flag the client, or flag the agency to make sure that a lot of complaints from here, but I think their past performance is not necessarily a proof performance is going to be as far as complaints go.
Certainly, and this is a learning experience for me too, as well as what needs to be presented to the board. I just didn't feel comfortable, so I wanted to bring it to you so that you could too provide me guidance on this is normal, this is to be expected, and that we're okay with this type of and they seem to be very full disclosure. They sent us their application is 166 pages, so they provided lots of detail. They are a 10 plus employee company.
Would you mind if I looked at it for just a second?
The other thing would be that if they're that large an agency, why are they just now being licensed in Tennessee? And that's
Another issue,
Yeah.
right.
And that is not a question that we ask.
just something that's in my mind.
it's not as large of a company as I first expected, and just in terms of revenue and that sort of thing. I guess I'm not compelled. I think we have to be very careful. Maybe it's more of a general statement, but just taking a number like that of complaints and denying an application because of it, because it could in fact be one creditor that turned over a batch of accounts that, was placed in error or something. You could get 14 complaints before you close the door this afternoon. I just want us to be careful about that.
That's true, except that they have already agreed that they paid $750 to $6,500 to settle these complaints, so likely they were unique complaints. I don't see that we can deny them a license based on the complaints. I don't think there's anything in our statute that lets that happen. But I do think we should flag that agency and make sure that they don't have a multitude of complaints going forward.
If, may I make a comment? I know I don't have it in front of me, but I've been listening to your conversation and what you said earlier about agencies. If they use a litigation approach, 2 or 3 complaints or suits a month on FDCPA violations is not uncommon. And they don't have to be that large, an agency to do that. So I really agree with your all's assessment that having a complaint against you in this environment does not necessarily mean that you're doing anything wrong, especially since they indicated they settled the complaints for various amounts. They're certainly being diligent in responding to them and resolving them, which to me is the larger issue.
Right.
And defending yourself in a complaint is a lot more expensive than $750 or $6,500 too. So a lot of times, and unfortunately, that's the way the consumer attorneys are, is because of the statute requiring.
Bart, the usual cost was anywhere from $2,500 to $3,500 to settle a single FDCPA violation with no real basis in a violation. Just the filing of a complaint will usually net the attorney's fees of probably $2,500, forgiveness of the debt, and of that $2,500, $250 will go to the debtor and the forgiveness of the balance. That's pretty routine with some of the embedded attorneys out there for them to accept.
I agree.
Do you need a motion?
I do need a motion because I have presented it to you.
I move we accept that application or approve that application.
A second.
Motion's been made and seconded. Ms. Whaley, if you'll make the roll call.
Art Howard,
Yes.
Elizabeth Trinkler,
Yes.
Elizabeth Dixon is absent, Chip Hellman,
Yes.
Steve Harb.
Yes.
The next application that I have for the board's review, and I will also need your approval on this one, is tab 7. Mr. Harb, I do believe this one, I was able to send this one to you.
I have tab 7. I have it open.
Okay, wonderful. And this company, their assets did not meet or exceed the liabilities.
For me, that's a pretty simple no.
Well, I wanted to present it in case there was something that the commission, the board felt if they needed more information about it.
They're not in business yet, is it? Is that the one I'm looking at? That's what their explanation is, that they haven't started collecting yet? It's a new,
Yeah, it appears to be very new.
and then if you look over, they've given a 6-month, that's what I was looking at, their 6-month operating expense budget, which looks a little strange to me because it shows them losing money through the first 8 months, but then all of a sudden in month 9, things turn around dramatically. I'm not sure what the explanation is for that. But
Well, it looks like loans from shareholders of $64,000. Do you see that, Steve, on page 14?
What troubles me is they've got a negative retained earnings. I'm looking at the RMA recovery balance sheet provided by the accountant, the compilation provided by Thomas B. Blatt CPA on January 26, 15, and there's the assets and liabilities. It would appear with negative retained earnings of $69,000 that they've been in business for a while doing something. And because they've lost money in prior years with that negative retained earnings, and that's the reason they don't have any equity, certainly as much as their assets, because they started out with $10,000 and managed to lose money. And taking a loan to cover your losses, well, now, it's interesting. It's a loan from shareholder for $64,000. Now, since we're being recorded, I won't be blunt about how unreasonable that is. If the shareholders took that $64,000 and put it into equity, then they have positive equity. So they're just playing accounting games so they can in the future take the money out. But on the face, we have no choice but to turn this down because they don't have enough invested. But again, that loan from shareholder puts them in a positive equity position. Y'all see what I'm talking about?
yeah,
I don't know how to address that except they're trying to. Well, there's the they had zero sales and only operating expenses, and that's why they lost in the period. So, Elizabeth, your comment that they aren't in operations is probably correct. If you look at their financial statement, they only show expenses in the first period, which might be startup.
that's
On-
what it is.
On their balance sheet, they show they've accumulated depreciation of almost $40,000 of depreciating the furniture and equipment. They've been doing something. I don't know what the depreciation schedule is, but it's more than a year.
But what they're doing, this might be a sub-S, and what they're doing is if you buy fixed assets, you can take a certain amount in the first year. You can take accelerated depreciation or there's a section, I can't give you the number, but you can depreciate $39,000 of the $40,000 in the first year and carry it forward. So we don't know enough to not know that that's many years or just the first year write-down. So I think it's $50,000, and I could be wrong on that. In the first year of fixed assets, you can just write off in the first year of acquisition. So it still could be a first year, but that's a good point about the depreciation. We just don't have enough information. But on the face, they don't meet our standard, which is you have to have more equity. So, I'm not making a motion or anything, but it would seem that we should at least write them and say, if they're willing to contribute the loans to shareholder to capital and redo their financial and represent it, then we could consider it. But I don't know that we can accept it this way.
On page 17 of their accounting notes, business depreciation, the company has been formed to operate a credit collection agency in various states after licenses for the activity have been obtained from state officials, departments, boards, or other legal bodies. So apparently they have been in business.
It doesn't say when they were formed, does it?
Only portion, if you go back to statement of cash flows, there is a cash balance of August 9th of $0.
What page is that?
Oh, I don't have it open.
Let's assume,
On page 16. I am happy to reach out to them and request additional information. We could request potentially a updated balance sheet or updated set of financials. Additional information about, are they a startup? I know there, one of the questions that we asked was about, the client's amount owed to zero. Amount owed to clients is zero, which is something we always ask. But they do say the corporation was formed on August 19th, 2014 in New York. This is several pages over.
Okay, so
So-
Steve,
And that explains it.
yeah, but Steve, let's just, you're the accounting guy, but let's assume that they've formed this company and they want to do it right. In other words, not engage in any collection activity until they're properly licensed. They would be spending money for the first, through the end of 2014, just trying to get licensed, right?
Yes.
So operating at a loss for those first 5 months or whatever would be normal if they're doing it the correct way.
Yeah, that's not an issue. The only issue I see is their accountant or someone advised them to loan the money to the corporation rather than put it in as equity.
Right.
And so, because it's a loan, and it's stated as a loan on the books, they can be repaid that money, and the company would have no equity. And that's good planning for a lot of reasons, but it's not good planning to try to get a license with positive equity. If they were to contribute that $64,479 to equity, then there's no reason we had a basis for denying them the license. Because they've pretty much done everything else, I think, from what I can see.
Well-
Their notes in the financials from the accountant are kind of crummy, but that's not our issue.
Doesn't seem like, to me, like they've got enough money. I mean, they've lost money now for the first 6 months getting going. And even in their projections, even when they start projecting some revenue, they're still going to lose money for the next 8 months. They don't have a lot of money to lose.
There's a footnote there that says
You're going to loan them some more money.
yeah, is to add $100,000 to the operating account at the rate of $25,000 per month, months 1 through 4.
Actually, I would say that a ramp-up company, if you start getting placements and start making collections, they're actually making a legitimate effort to give reasonable or rational projections, because you're going to lose money for the first 4 to 6 months, because when you look at the collection cycle from placement to collection and to the time you actually receive your first payment, if you're a gross pay client, it could be 3 to 6 months before you start seeing any money at all from collection efforts.
Well,
So it's pretty rational what they've done.
Yep. If you, on page 23, which is what Elizabeth was referring to earlier, that's showing, sort of a slow growth in revenue until month 9, and then it pops. Their note on this, they're obviously rehabbing student loans. The whole rehab process takes 9 months. But once you rehab a student loan, you get commissioned on the entire loan balance. That's why these student loan shops are making so much money. If they're
That's why they're showing the big pop in
Yeah.
month 9.
that's exactly why.
And they've made a diligent effort to give rational projections, which I, quite frankly, appreciate. They just need to put more money in the company now and have positive equity, and they're good to go from an accounting perspective.
The other thing that I noticed is they're from Buffalo, New York, and there have been a beehive of
Oh, my gosh.
problems from Buffalo, New York, and I just wonder if this fellow Ken is part of that beehive. We don't want.
Back on him. Did you read the book? I have I can't even remember the name. About the buying and selling of debt up there and all those players in Buffalo, but it is. But we can't.
We can't
We have no
deny
basis
based
to-
on that. We don't have any reason to believe that. I think that if we write them a letter and ask them when are they now in the collection business? I know the student loan, if this is what they're doing, do they have contracts with the student loan folks? Or are they currently doing operating business anywhere in collections at all?
The letter on page 27 addresses what you're saying. Please keep in mind RMA is a startup company that is not actually starting in collections operations yet. Our business is established 8/19, and we're in the process of being licensed and will not do active collections until we receive the bulk of the state license. Anticipated date is mid to the end of February 2015. They're actually approaching it in a fairly responsible way for the reality of getting collection business started. I can't fault them in that. They don't have to be brain trust to be in the business, but what they're saying is rational.
So what is it we want from them before we grant this license?
I'd want new financial statements from the accountant showing that they've contributed the $64,000 to capital, and that they've also added additional capital that they say they're going to put in, so they have positive equity. And beyond that, what else can we ask for?
We just asked them to reproduce financials that indicates positive equity.
Yeah, and then they need to figure out how to
They need to figure out how to do it, but
I'll make that motion.
motion's been made. Is there a second?
Second.
Motion's made and seconded. Ms. Whaley, if you'll call the roll, please.
And I want to make sure, we really are just asking them to provide, to show positive financial position and provide us with a new set of financials. That's the extent of what we're going to ask them for, correct?
Positive equity, right, Steve?
Yes.
That's the motion.
They need to provide that before we issue the license, yeah.
Absolutely. I will represent this to the board. Given anytime that I present one and we ask for additional information, I will make sure it's represented to the board. Final approval.
Well, I'm not sure we want to delay their license for another 60 days based on that. I think if they provide that to your satisfaction, then I think the license could be issued. Is that a problem?
Yes, so whatever I need to do to follow Robert's rules correctly, I'd like to
Motion?
amend my motion
Okay.
to give you the authority to approve this application once you review new financial statements that reflect a positive equity
Provided by the CPA.
provided by the CPA.
Absolutely.
That's my motion, Mr. Chairman.
Okay,
I renew my second.
need the second. Ms. Whaley?
Art Howard,
Yes.
Elizabeth Trinkler,
Yes.
Elizabeth Dixon is absent, Chip Hellman,
Yes.
Steve Harb.
Yes.
Okay, wonderful.
Ma'am.
Okay, in keeping with the application review, and Mr. Harb and I discussed this yesterday, that I could not send him all of these files that you have before you. So I just wanted to, if you'd like to have a conversation about the reviewing of applications, which was requested at the last meeting, and I've provided those, the original copies in front of you. Additionally, I'd like to pass out the collection service application as it currently is, so that you each can it. If this is something you would prefer to take home, look at, and us discuss next meeting, that's completely acceptable. I do feel it is time that we revise it. And we will work, revisions, of course, we will work with legal as well to ensure that whatever additional the board wants to ask of applicants or require of applicants is in line with the laws and rules of the board.
I think we have these,
Can I say something?
sir.
I told Kimberly earlier that I needed to sign off at 11:30, but and it's 11:40. but you still have a quorum at this point if I sign off. Is that correct?
Correct.
My only comments about reviewing or revising the application is first, I don't personally feel the board should review every application that comes through. I think our staff should do that. And if we want to review 2 or 3 that, on an occasional basis, that'd be reasonable. But I do agree the application needs to be revised. And with that, if it's not an issue, I need to sign off.
One comment that I'd like to make, Steve, before you sign off, is that we all understand that we should not get together away from this meeting to discuss this application or any other board business, and we can review.
Sunset laws apply.
Yes, sir.
Yes, sir. And if anyone has any questions, you can direct those to myself or Ms. Baird.
Thanks, Steve.
Thank you very much.
Steve.
Thank
Thank you, Mr. Harb.
Thanks for tolerating me being by the phone, y'all.
That's all right. It's worked fine.
Bye-bye.
I agree, and we briefly, the three of us here briefly looked at these applications, and I think it's superfluous for us to sit here and try to go through these applications and make some kind of determination whether they're qualified or not qualified. I suppose Judy Elmore still does these applications. She's excellent, done it a long time, very well qualified, and I don't think there's any necessary problems. And I'm not sure what we were looking for before when we said we wanted to see them. But I think an application redo is well in order, and we can ask the questions that we want to know on the application to determine whether they be qualified.
Yes, and in that revision, you can direct us, especially if there is something in particular that now you want us to focus on in our review. Judy receives all of the applications. Just to give you an update on how the process works, Judy reviews all of the applications that come in, and she reaches out to them if they are lacking documents or lacking information, and works with them to get the files. Once the files are complete, they are forwarded to myself, along with the gentleman that appeared earlier is Bill Huddleston. He is the CPA in our office, and he or I will actually review the financial statement and do a secondary check of the files prior to approval. So just a quick snippet of what we do, and if there's any question about if they've disclosed something related to civil suits or whatnot, I will work with legal counsel, Chris, and now Ms. Baird.
Kind of an example of what we wanted to see is this agency that we just spoke about that's applying from Buffalo. I'd like to know if that fellow worked for any other agencies up there or any.
Okay.
That's the kind of thing we'd like to
And
know.
that's something we can look at if you want to know information about the officers. Again, you can present anything that you would like to know, and then Ms. Baird will review it to determine if we are legally allowed to ask that question. And it'll be a joint process over time, probably over the next 2 meetings, for us to come to a new version. Ultimately, the board will vote on the final version, and then I will submit it to Forms Review, and then we publish a new application, and we will publish that online as well.
Motion?
I don't believe so, not at this time. Of course, we'll need, when we actually do make changes to the agenda, or the applications, forgive me.
Okay, where are we now on the renewal update?
Yes, sir. Renewal update. There's not anything on your iPads related to this. This is a question that I'm just kind of providing an update at each meeting about the number of agencies. I believe Mr. Hellman inquired a few months back about the number of agencies, if we had seen agencies dropping off. And we currently, since last meeting, we've had 13 additional companies surrender their licenses. Many times they do not provide us with a reason for why they are surrendering their license. Some are closing, some just say they're no longer going to do business in Tennessee. But that's the extent of really what we get back from them. It's been a total of 23 surrenders since we began keeping track back in November.
Okay. And so we don't really have anything to compare that to yet, but as we move along, we'll be able to compare it back against last year's same period
Yes,
and that
sir.
sort of thing.
Absolutely. We'll be able to see exactly how many.
23 surrenders since November seems like it seems like a lot, but again, we don't have anything to compare it to.
Right. I will say one of the companies was 7 licenses. There were 7 licenses for one company. They had multiple locations that were collecting, so that was one company deciding that they no longer need a license. There's another company that had 2 licenses, another company that had 3 licenses, and another that had 2. Actually, I think that's 4 in total. So we continue to keep track of that. I have Judy keeping a spreadsheet of when we receive those and when we close.
How many new ones did we get?
Up on my iPad. We have received, I can quickly, since November 15, 20.
Wow.
40 new and 23 surrenders.
Looking at the renewal cycle, since we went through the renewal cycle just recently, and there are still some who are continuing to finish up the process there. The change to the balance sheet requirement has caused some of the companies to have to go back to their CPA. But we had 237 that expired in the month of December. Of those, 192 have currently renewed. So that's a difference of 45.
Yep.
So we knew we might see some people just not renew instead of actually surrendering their license simply because they were coming right up against that renewal. So
Tough business now. It's not like it used to be in the old days, is it?
and I just want to make sure this is the information you were seeking.
Yeah, that's good. I think we need to be watching this.
Okay.
I really do.
Absolutely. I just want to make sure when you ask those questions that I do fully provide what you want. So feel free to give me any feedback you like.
Yeah.
Excellent.
Okay.
Thank you.
The final item is a legislative update, and the only piece of legislation, we've discussed this before, and this also would impact the applications that we will have, if this were to pass, we would have to make that. And this is the budget requirement being removed, I believe, last meeting. The proposed
6
budget,
months, budget, yeah.
being removed. So that will trigger automatically, if it were to pass, would trigger a application review. So I think this is a very timely review of the application. If this does pass, we'd have to change it. So I will just give you a quick update. It is engrossed and ready for transmission to the House, and it has been assigned to the House Business and Utilities Subcommittee. So update is as of the 9th.
Does that, legislatively speaking, does that mean that that the whole act can be opened and somebody can make motions that this happened, that happened, and so forth?
I don't have the full legislation in front of me. I would have to see what the caption said, if it opened specifically relevant to this section. I think this one is specific to exactly to this, as opposed to opening 6220, which is the entire collection service statute.
I don't know what they'll do to it if they open the whole thing.
This is part of an administrative package, so this is a very
Okay. Specific.
this is along with several other departmental and agency bills. I believe it is very, very specific, but do not hold me to that.
Business?
Well, I just want to, and I don't want to delay us here. No, I don't have any new business, but I just have to, I guess, sort of make the comment. Maybe everyone's tuned in, but we've alluded throughout today's meeting and about how difficult this industry is right now. And I work in the area of compliance now for third-party collection companies, debt buyers, and law firms. And this is really a tough industry to be in. And there's so many changes that this isn't a season where I think this board just sort of needs to be on autopilot. I think we have to stay tuned. Front page of the Wall Street Journal on Monday morning, the credit report, 3 credit reporting agencies have agreed to, with the Attorney General of New York, to implement these radical changes to the reporting, the way the reporting's done, and they've agreed to take it nationwide. And with the Consumer Financial Protection Bureau involved and all the state attorney generals watching, I mean, it's a very dynamic area, and things are changing almost daily. That Wall Street Journal article, if you haven't read it on Monday morning, really puts an exclamation point on that statement. I just think we have to all stay real tuned into this industry right now because things are moving so quickly. For example, one of the changes is that healthcare debt cannot be reported to the credit bureaus, the 3 credit reporting agencies, until it's at least 180 days old. So that's a simple system fix for most companies, but there are going to be massive numbers of violations once that's implemented. Certain types of debt that could be reported before cannot be reported any longer. Things like fees, fines, and costs for court clerks. You can't report that stuff anymore as this gets implemented. We're seeing just a huge change, and I think all of that, the reason I want to keep my eye on the renewals and the people surrendering, I think there's going to be a consolidation, no doubt. Everyone's predicting it because the small and medium-sized companies just can't comply with the new regulations, and so they're going to get out of the business one way or another. They're going to sell or shut down. It's just a lot of movement. I just want to encourage us all to stay as tuned in as we can, so that we can also, and I know this board, we're all doing that, but it's going to be an interesting next couple of years in this industry. Very interesting. Some huge TCPA class action lawsuits are out there, and courts are conflicting with one another as things move up through the appeals process. And one court rules one way and another court rules another way on the exact same matter, and that it's very interesting. So I'm seeing it every day, Bart.
I know you are, so I've been out of the business for 5 years, and it was nuts then. I can't imagine what it is like.
Crazy. I mean, people literally, people are getting lawsuits and complaints and e-Oscar disputes, and now part of what that Wall Street Journal article is saying is that consumer disputes are going to be taken very, very seriously, and 3 major credit reporting agencies have to actually hire skilled people to work with the consumers to help them resolve credit disputes. And I mean, it's a big deal. There's a lot of movement out there. So just a editorial comment.
Business? If not, we'll stand adjourned.
Parking space.
You got a parking space?
Yes,
Oh
I
my
do.
gosh.
And a driver's license.